Hello and good afternoon. Thank you for watching UBC television. My name is Wadulo Anorld and I'm honored to be giving you the lunchtime news, the weekly roundup edition, this 21st day of February 2021. Now to start out from some of our top stories from the week, President Yoweri Kaguta Museveni's lawyers on Friday adduced that they find no conclusive evidence brought to court for consideration by the National Unity Platform lawyers. The response was premised on affidavits tendered before court by Robert Chagulanyi's lead counsel, Medet Segona, detailing arrests and kidnaps of some key witnesses in Chagulanyi's case. However, the Supreme Court declined to grant leave to the petitioner to file the remaining 200 affidavits in his petition file. More details in this report.
Following the decline of the Supreme Court, the plea by Robert Chagulanyi's legal team to submit additional affidavits, incumbent Museveni's lawyers have had what many scholars had alluded to as an easy walk in the national park, describing NUP's trashed affidavit as containing no conclusive evidence on the subject matter before court. NUP lawyers had earlier asked court to grant them leave to add more implicating affidavits, but in tonight's court ruling, presided over by the Chief Justice Wadulo, the court's circumstantial ruling has collapsed NUP's plea on dry rocks.
We have given due consideration to the application and submissions of counsel for the applicant and for the respondents. By a majority of 8-1, this court disallows this application. Court shall be in the cause. The detailed reasons for the ruling will be contained in the detailed judgment, dated at Kampala this 19th day of February 2021 and signed.
In court, where the applicant's legal team, led by counsel Medet Segona, prayed to court to allow the application, saying it raises special circumstances.
Again, we submit that our case has been made for special circumstances. While we talk about 50% of the time, counsel for the respondents do not compute the time they deliberately and illegally took away from the petition. But it does not stop there, because the case for you now is not the petition. Those predicaments that predated the filing of the petition have continued to punctuate the proceedings that continue today. And that's the reason, among others, why we're here.
Segona also based his evidence on the arrests and kidnaps of some key witnesses by security operatives, which they claim hindered them from meeting the deadline and gathering all the required evidence as directed by court. However, this was objected by Museveni's lawyer Kiryowa Kiwanuka, who told the court that there is no conclusive evidence brought to court to consider the said allegations.
It is also prudent always that for a litigant to come to court, they must have evidence. We have gotten to the point where we now practice the other way around. I first file a writ. After filing the writ, I look for the evidence. That is what you're getting. That is what is before your lordships. That I had a petition, but now I'm looking for the evidence. How is that possible? How can you achieve a grievance before you see the evidence? How can you say that my would-be witnesses are in prison? How do you arrive at the conclusion that they would be witnesses before interviewing? It's preposterous, my lord. It's preposterous, my lord, and this is the kind of conduct that this court must absolutely reject.
Joseph Masiko, the Electoral Commission lawyer, told court that the application is incompetent before court, saying court had fixed time of only 45 days to give a verdict. Against this submission, the respondents prayed to court to dismiss the application with the costs.
Counsel Segona on the same record is quoted as having said that they were going to be more prepared going forward. My lords, what we are seeing now is the exact opposite of that. As this court noted, not only did they fail to serve the 50 or so affidavits on the 11th, but even when time was enlarged, and my lord, the record is clear that this court gave them an additional 4 days. The court noted that they had 10 days And the court noted that they're giving them an additional 4 days. Even then, my lords, the filing was on the very last dot of 5 p.m.
Meanwhile, Supreme Court declined to grant leave for Robert to file the remaining 200 affidavits in his petition file before this court. Bernard Higa and Deborah Namamonde, UBC News.
In a related matter, the Chief Justice Alfonso Wadulo has this week criticized National Unity Platform leader Robert Kyagulanyi Ssentamu over continued prejudice and discrediting of the Supreme Court. Now, he was presiding over court determining the fate of Kyagulanyi's petition, seeking court to grant leave to his team of lawyers to submit more affidavits.
Ever since Robert Kyagulanyi petitioned the Supreme Court of Uganda as regards to the 2021 presidential results, he has on several occasions expressed dismay to the processes and particularly to some members of the bench.
That evidence has been adduced all through the hearing, and we fail to understand why the Supreme Court rejects the evidence that we are bringing before it.
It is on this background and the others that the Attorney General William Beruhanga has made a submission to court, putting in question the manner in which the proceedings are taking shape in contravention of the law governing the judiciary and the time frame on submissions.
Honorable Ssentamu Kyagulanyi, who is the applicant currently, made reference to his displeasure at the participation of 3 judges of the Supreme Court. Now, my lord, of course, it behoves all lawyers of this court to desist, either them themselves, and indeed, if not them, to impress it upon their clients that a trial, any trial, but of course especially a presidential petition, is very serious business.
William Beruhanga, the head of the legal bar, lamented over the continued interference by the petitioner Robert Kyagulanyi in the court processes through several media lash-outs to the Supreme Court bench.
This Supreme Court is the highest court of our land, and it operates in an open and transparent judicial environment. The necessary respect must be accorded to the court. And all counsel, indeed everybody, are duty-bound to adhere to this. Specifically, he called a press conference at which he requested, actually he vilified 3 judges of this bench and asked them to recuse themselves on the basis, and I quote, that they do not have confidence that they will get justice while at least these 3 judges or justices are on the quorum. This, I'm just quoting him. Now, my lords, of course, a litigant is perfectly within his rights to seek a recusal. Only that the venue for doing that is here, before this court.
The lead counsel to the National Unity Platform Party, Medal Lubega Segona, made a counter submission to that of the legal principal advisor to government, the Attorney General.
I agree that a matter in court should be in the exclusive hands and 4 corners of court and nowhere else. And that has been my practice for the last 18 years. The Attorney General has equally not availed me with an opportunity to look at the material that he was able to look at.
With the submission, matters did not go down well with the Chief Justice Wadulo lashing at Kyagulanyi's continued verbatim attacks on members of the bench through media reports.
If anybody has any issue to raise with any of the judges here, this is the forum. They come before us, present their case, and we attend to it. Without fear, without favor, without affection or ill will.
Doro, without missing words, warned that no one will intimidate, prejudice or demystify the court process.
Fortunately, I know the Chief Justice of Uganda very well. I think I've known since childhood. If anyone thinks he can intimidate, he can blackmail, he can induce with favors, that Chief Justice of Uganda, then he's heading for a crash.
He, however, assures parties in the case before court that justice will be fairly accorded to them, and thus calling for respect and avoidance of holding the oath of justice in contempt.
I give you the assurance we will proceed with this application, we will proceed with the petition, and nobody should have the fear that we will favor any person or we bear ill will against any person. We'll act according to the dictates of our oath. We are not opposed to fair criticism. I said this before. And the positions we hold, we expect criticism. We never invited anybody to come to court. If you have a plan B, you don't even need our permission. You pursue your plan B, for us will be done with whatever is before us.
Robert Onyango, UBC News, Kampala.
Now, the next day to that, President Yoweri Kaguta Museveni, the Attorney General, and the Electoral Commission this weekend filed 185 affidavits in response to NUP's lawyer petition. The trio are being challenged in court by Robert Kyagulanyi, the president of the National Unity Platform.
We have successfully managed to comply with the court directives.
Lawyers of President Yoweri Kaguta Museveni, the Electoral Commission and the Attorney General have this Saturday filed their responses to the presidential elections petition of 2021 by Robert Kyagulanyi Center of National Unity Platform. President Museveni was represented by lawyers Enoka Barata, Esawe Singoma, Osama Sebufo, and George Karimera from Kihika and Kiriowa Chiwanuka Company Advocates. The Electoral Commission was represented by Counsel John Jet Tumwebaze and Aaron Mukama from the Attorney General's chambers. The affidavits were received by Ronald Luwangula and Henry Mugoya from the Office of the Registrar Supreme Court. President Museveni based his affidavits from 35 witnesses, including the NRM General Secretary Justin Kasule Lumumba, Minister for Presidents Esther Mbayo, among other witnesses.
They are ordinary people from voters to agents to just ordinary people that were perhaps accused in the various affidavits we have seen. The first respondent, President Museveni, already filed his affidavit, as you recall.
Enoka Barata says issues filed in the affidavits by President Yoweri Kaguta Museveni's defense team are sufficient to defend their client in the petition.
This is varied. There are varied allegations in the various affidavits, and we have responded to those. If you have seen the petition, there are allegations of connivance with perhaps the UPDF or the police. We have some allegations of bribery.
The Electoral Commission, the second respondent in this petition, presented 74 affidavits in reply to Robert Kyagulanyi Sentamu's petition.
But there were allegations, some place in Sinjiro, some place in Kabongo, one place in Busia. So the allegations, the polling stations are actually not many, the ones which are affected. And of course there were a few allegations on polling stations which the second respondent itself found those issues by themselves and cancelled the results.
Jet Tumwebaze says the Electoral Commission has responded to the allegations of vote stuffing and errors at some polling stations.
The results that came from the polling station in the DR forms are actually reflected in the district tally sheets. And the tally sheets are actually online. The tally sheets are online. In fact, we've just gotten them online. They're there. If you have a DR form and you want to know whether the results you have in that DR form are in the tally sheet, go to the Electoral Commission website.
Tumwebaze also adds that they are sure these grounds have been well addressed by the second respondent. Issues concerning Uganda People's Defence Forces and Uganda Police were addressed by Alan Mukama from the Attorney General's chambers. The three respondents in the presidential petition have filed 185 affidavits as a reply to the 53 affidavits filed by the petitioner. Robert Kyagulanyi Sentamu was represented by Counsel Kigozi Donald and Nabunye Irene from Lukwagan Company Advocates. Court will resume on 24th February 2021 to proceed with the hearing of the case. Deborah Namamonde, UBC News.
Now into other matters, Uganda National Examinations Board, UNEB, this week released timetables for the 2020 primary leaving examinations, Uganda Certificate of Education and Uganda Advanced Certificate of Education. Now the Executive Secretary UNEB, Dan Nokoracho Dongo, said that the examinations will be standard, the grading protocol will remain and the content of examination papers will too remain. Now UCE begins 26th of February, PLE begins 26th of March, while USCE begins on 9th April with briefing.
Uganda National Examinations Board is set to conduct the 2020 Uganda Certificate of Education examinations beginning on 26th February, primary leaving examinations on 26th March, and Uganda Advanced Certificate of Education examinations begins on 9th April. Each of the seasons begins with a briefing. At least 749,811 candidates are expected to appear for PLE exams, while 333,775 candidates will appear for Uganda Certificate of Education examinations and 98,379 candidates for Uganda Advanced Certificate of Examinations. The Executive Secretary UNEB, Dan Nokoracho Dong, however, says there are reports of people who have started selling papers they say are of the 2020 PLE in Mubende.
We want to warn very, very strongly those directors and head teachers who want to celebrate results that have been obtained through fraud, that this time round the board is going to be extremely harsh and on any other person who will indulge in this examination malpractice. Reports that we have received from Mubende area indicates that already some people are selling what they say are the PLE papers which are coming in the examination, and some schools are busy buying these at 150,000 per paper, even before the PLE paper has actually been printed. So we want to warn the public that no paper from UNEB can be available except when the exams are in process.
Uganda National Examinations Board says they are aware COVID-19 affected learners but have set standard examinations and insist that the grading protocols and content of examinations will remain.
We came back. We believe that schools made all the efforts to try and cover as much of the curriculum as they can. But we want to say that the examinations will be standard. You cannot say that the 2020 examination was a watered down version because of COVID-19. We still want to say, despite all the challenges that the candidates had, they were able to pass at this level. Grading, the setting is a standard setting, covering the syllabus for primary, UCE and USCE. And the grading protocols that have been used will also be observed. We do not want a situation where other countries doubt our credentials, our awards, because we have said, yes, this year, in order to get a distinction one, all you need is 50%. We don't.
Complying with the standard operating procedures on COVID-19 in conducting the 2020 examinations necessitated increasing the budget of UNEB. They requested for a supplementary of 10.5 billion shillings, which was granted by Parliament.
Therefore, the funds we had for running the examinations, whereas they would have been adequate under normal circumstances, when you are talking about another 35,000 invigilators that are required, several other marking centers that are required, our arithmetic gave us that figure. We presented this, and I am glad to say, at least from what I learned, that Parliament passed our request for supplementary funding.
Meanwhile, the UNEB Bill 2020 was passed into law by Parliament and it is pending the President's assent. Accordingly, this bill will become the UNEB Act and expands the scope of offences and sanctions. If assented to within this period, the examinations will be conducted in accordance to the new law. I'm Navka Farida in Kampala.
In other news from this week, government criticized the European Union resolution urging member states to slap sanctions on the Uganda government officials and some agencies on grounds of violations of human rights. Now, the government spokesperson Ofono Opondo and the Minister for ICT and National Guidance, Judith Nabakova, have all maintained that the sovereignty of Ugandans must be respected amidst all circumstances. More details to the story.
In a resolution letter dated 11th February 2021 and copied to the government of Uganda and EU member states, recommendations which included sanctions to some Ugandan government officials and agencies on grounds of continued violation of human rights were made. Since then, the government of Uganda has responded with utmost concern.
Our perspective as a country, because if you talk about we did not follow the law, you remember that we are still in a COVID situation. We have a pandemic around with us, and we had to do an election, but being mindful of the lives or the electorates, because we did not want everybody to get the virus.
That statement, in short, they said the election was credible. This, particularly the polling day, they said it was peaceful. It has never been as peaceful as that election. That's what they said themselves. So it was a surprise to us that they entertained this in their parliament. But be that as to me, assuming somebody complained or raised, they never informed our embassy in Brussels that there was a complaint so that we would respond. We only saw the resolution. We are still trying to understand the motivation for the resolution tainted with the clear falsehood and the mix-up of issues.
Among the grounds in EU's resolution, the arrest of human rights activists and lawyer Nicholas Opio, whom government of Uganda recently slapped with charges related to money laundering, purported arrest and detention of Ugandans, among others.
They mix it up with issues of homosexuals.